excited to have great speakers on this call today, and very exciting topics. At least to me, they are very exciting. So thank you, Jocelyn, for giving us insight on Brexit and what's going to happen with GDPR and the general relationship when it comes to data protection between the UK and the rest of Europe and the rest of the world. And then Janina and Asta, I don't know, am I pronouncing that right? Or okay, good. The one thing that I've learned about Finnish is just that it's always just spelled as it's written. So I didn't have a, okay, good. So I managed that. To tell us something about the new model clauses that you probably all know have been published after a very long wait, and were highly expected to solve all our problems. I'm not sure that they have achieved that goal, but at least it's a lot better than it was before. And then we've got Renee from Germany as well, who will tell us about the recent developments around GDPR enforcement and fines, because we're tracking all the fines that are being published regarding GDPR, and in the end, it's all about money. That's what drives GDPR compliance, at least in our experience. So frankly, I'm not really sure which topic we wanted to start with. Hannah, you sent out the agenda, and I think the first one is just messed up by my email.
This is the Brexit. This is I only put these in order of what they came across in my email. So if you're fine with that, we can go ahead and start with Brexit and the future of UK data protection with Jocelyn.
Yeah, happy to do that. Okay, thanks, Hannah. Thanks, Christian. Really nice to meet everyone and join this group. I haven't joined before, but I look forward to joining on a regular basis from now on. So, UK and Brexit. Christian was just starting to get all excited about this before everyone else joined, and saying that now is possibly the most exciting time in certainly UK data protection legislation, because it's becoming quite politicised for the first time, which is not an angle we've really seen around privacy related laws in the UK before. So obviously that's all stemmed from the vote by a very slight majority of British people to leave the European Union. And then we've had to go through all our legislation that derives from those European laws to work out how we're going to deal with it. So the general rule is that anything that was integrated into English law on withdrawal day, so the 31st of December last year, is crystallised into English law. And from a data protection point of view, we'd already done that anyway, because the Data Protection Act 2018 came out alongside implementation of GDPR. And what our DPA does is it says, here's our national legislation, we incorporate in any event all the European GDPR, and then we've put some of our national derogations around it in the DPA. So, for example, extra grounds for processing for special category data, public interest tests, pieces around law enforcement and special intelligence use of personal data. So that was quite settled even in the run up to Brexit. That didn't really cause anyone any concerns. The biggest question in the run up to Brexit actually occurring was what will happen in respect of international transfers. So the ICO came out really early on and said that Europe will effectively have the benefit of an adequacy decision from the UK point of view. So UK into EU transfers, no problem, all adequate, no additional paperwork needed. The bit we were on tenterhooks for was waiting to see what the European Commission said vis-a-vis the UK, which only came, I think, 3 days before the end of the bridging period, as we called it, up to the end of June this year, before the European Commission finally said, yes, okay, UK, we will also grant you adequacy. So EU to UK transfers, no additional paperwork needed. Of course, though, that's not a complete blessing in two respects. For the first time ever, there is a sunset clause within the adequacy decision, which effectively says this decision is subject to review at any point in time. If the UK's practices diverge too far from what the European Commission deemed to be sufficient protections, then this decision may be revisited, and in any event, it expires 4 years from the date it was given. So we've got sort of medium-term comfort that those transfers from EU to UK will just continue uninterrupted, but we've certainly been advising clients in terms of all their data mapping to now distinguish between UK and EU transfers, whereas before we didn't used to because it was all part of one system. So that as and when, almost inevitably, I think, something will happen in the future, they will know how to deal with that. And the reason I'm saying it's almost inevitable is because the UK government has fairly recently, within the last couple of months, published information to say they are looking at giving adequacy to 10 other third countries, top of the list being the US. And of course, we all know the European Commission's view on the adequacy of the US privacy laws. So it seems to me, and the drive for this does seem to be political. When you look at the rhetoric and the reasoning around it, the government are very much relying on looking at how much we trade with the other countries. They're looking at the value of that trade, promoting innovation, strengthening those international ties. And the decision for who can grant adequacy to those countries now sits with the Secretary of State. It is not an ICO decision. So the power really has shifted over onto the political side. And the government seems to be using this as a really live example of how they want to exercise their independence from the EU going forward by bringing this issue of data and linking it to trade and putting that front and centre and saying we want to make life easier and less administratively burdensome for everyone. So let's try and give adequacy decisions to this much longer list of countries with whom we want to strengthen our trade ties. But of course, the obvious question is, if the UK goes ahead and does that, what will be the impact for the adequacy decision that's already been given by the European Commission for the transfers from the EU to the UK? So that'll be really interesting to see what happens. The ICO will have an advisory role as the government look at this adequacy decision, and they've signed a memorandum of understanding, but it's quite clear that the decision maker is the government and the Secretary of State. So it's definitely becoming more politicised. There's also other things going on slightly more in the background. The government is putting together an expert council of advisors on international transfers, presumably to help with their decision and assessment of adequacy in other territories. So that's going to be a council of 15 experts. Their applications are open at the moment for within the UK people who want to be on that panel. So that's quite interesting to see that moving in the background. And there's also been a lot of political interest in our new information commissioner, because that has changed over just this time. It is now the ex-New Zealand commissioner who is coming on board in the UK, and sort of reading between the lines of the government's announcements around that, sort of welcoming the new commissioner on board. There seems to be an edge of, we want someone who's going to work with us really constructively to take this area forward, rather than being that very independent regulator, sort of purely looking at upholding rights and freedoms of individuals rather than complying with the political agenda. So that's all interesting ties. And then the sort of even bigger stake in the ground just now is 10th of September, DCMS, which is the Department for Culture, Media and Sport, issued a consultation in the UK called Data a New Direction, ? And in it, they are consulting on various reforms to the DPA, GDPR, not really fundamental things. They're not looking to destroy the main 6 principles, to change accountability, but they are consulting on areas around research purposes and repurposing of data. They say to give companies more comfort around what they can legally do in those areas and to make it easier. Also around legitimate interests, saying we feel companies are not very confident in processing on the basis of legitimate interest because they don't understand what it means, and suggesting we might have an exhaustive list of what can be a legitimate interest, which makes me very nervous indeed. Also looking at, you won't be surprised to hear, AI, because the UK government's been doing an awful lot around AI. We seem to have endless quasi-advisory bodies on the topic of AI. So very interested in how DP reform needs to move alongside that agenda. Looking at things like improved public service use of data, given what happened during COVID and the advantages there were to being able to share data more easily. How do we make the most of that to assist the economy? And lastly, reform of the ICO's office. The main suggestion being that the government will appoint the chief exec of the ICO. So again, creating more political links between the government and what we normally see as a very independent regulator, which unsurprisingly, the ICO has come out and expressed some concerns as to how that might operate in practice. And the last thing I wanted to mention, slightly broader than just pure data protection, is the PECA and cookie agenda. Because obviously in Europe, it looks like you're finally inching closer to getting the new e-privacy directive. As the UK obviously isn't going to automatically adopt that. But the ICO has been really active around cookies, and I know raised it at the G7 summit in September as the item that the ICO brought to the table, saying we think there needs to be greater global cooperation on cookies, so taking it outside even of a European agenda and putting it on the world stage. So that was interesting to see as maybe a counter move as to things changing in Europe and the ICO trying to getting up on a global agenda, which I thought is overall helpful. You know, when we're advising clients, it is absolutely a global issue, and so taking it in that direction rather than just looking to Europe. That's what I was going to cover. Very happy to talk more about any of that, although I don't have any great insights into what the government's actually going to do next. I wish I did.
Thank you very much. I really you mentioned that right at the beginning of your presentation, that this is now a very political topic, and not only internally in the UK, but also between Europe and the UK. I mean, to be frank, I was kind of surprised to see someone from New Zealand to be appointed as a new ICO head, but that's maybe something that doesn't surprise maybe you, because I know that a lot of UK lawyers actually from New Zealand or from Australia, so it may be totally normal. But to me, the first thing that came to mind was, okay, this is just a sign to, well, now to have a more global approach when it comes to data protection and stuff like that. Do you think that's what it was, or was it just a recruitment decision?
No, I think you're right. It was slightly two fingers in the air and to pull a candidate from somewhere outside of Europe. I mean, the ICO, I think for the last few years has been trying to play more on a world stage, been being seen at more global privacy events, and having memorandum of understandings with other commissioners in other countries. So I think you're right, Christian. It's saying we're not going to look like we're dependent on Europe by recruiting our next commissioner from one of the European regions, but looking outside. I mean, I know there's been ties to Canada before. We've had ex-Canadian commissioners as well. So they do seem to have a bit of a history to looking to sort of the other countries where the UK has had more influence than maybe other experienced regulators from Europe.
Mm. Do you feel that there's any impact already on companies, just simply based on data protection and the concerns that it may be more difficult to exchange data between Europe and the UK in the future due to Brexit? Or is this something that doesn't play a role? In my experience, from looking at Germany, it's something which I think it was expected by most people that this adequacy decision would be there. But I think it's an underlying concern that something may happen in future, and it kind of may halt investment a bit. Sorry.
Yeah, I think you're right. I think it's something that people, when they're looking at where do they locate and where do they want to be, would have on their list of things I might need to think about, but I've not actually seen it sway anybody's decision as being such an important factor in a particular business model that they've made the decision based on data protection impact. I think there is an element of trusting that the government will be sufficiently pragmatic that whatever they do won't make life harder for anyone here, because obviously all their indications is we want to make it easier, reduce admin, reduce bureaucracy, and make it easier, particularly for SMEs to comply and startups. And that's quite high on their agenda. So I think there is a level of trust that we will do something that's sensible and helpful and not create more difficulties for people who are trying to be active on a global scale.
Yeah.
Sorry, I have a question, and forgive me if it seems to be a little bit too basic, but from Asia looking into Europe, we've got many companies trying to navigate GDPR compliance, obviously. So the story so far, as we have understood it, is that the UK adopted the GDPR, drew a line, and then now the CJEU is not the final, does not have the final say on the interpretation of the UK GDPR, obviously. So the UK is free to kind of chart its own course, right, in terms of the interpretation of how it's going to be viewing or interpreting the operation of the GDPR. How has this, and I think, you know, Jocelyn, the stuff that you were just mentioning kind of just underscores, right, the politics of it all and so forth. So for companies in Europe looking to, say, address the UK market, are you seeing a trend where there is increasingly a recognition that, well, separate advice needs to be obtained to address the compliance, and also to all of the European colleagues on the call? What do you see, you know, in terms of your own reaction to this development that's happening in the UK? How are clients approaching the issue of GDPR compliance, even though technically you're dealing with the same legislation? But yeah, in time to come, you know, there's going to be this divergence.
Yeah, I think it's definitely something clients are looking at and considering. I think you're right. I have had one client who had asked us for slightly unusually an opinion, a formal opinion on GDPR compliance of a particular entity that they were entering a contract with. And the instruction came through to me in the UK, but we actually realised the entity with regard to whom the opinion was going to be given was a French entity. So I actually ended up handing it over to my colleague in France, because for something like an opinion, we concluded you really did want a lawyer in the correct jurisdiction to be giving that opinion. So yes, there it did matter. Otherwise, it's a bit like lots of things with GDPR, depends how proportionate it is to whatever they're doing. So there is still a level of, when we're talking to clients in the UK who are maybe expanding into Europe and we're doing things like privacy notices on websites and cookie notices, our advice is still, at the moment, this is still all 99.9% the same. Obviously, there's local DPO variations and things like that.
Yeah.
But if it's that kind of level of risk, then go with it. If you're talking about your entire business is going to revolve around collecting consumer data and profiling them and doing much more high risk activities, then you would be well advised to go off and get separate advice. But yes, I am definitely seeing clients thinking more about, is this UK data protection advice I want or European DP advice,
right,
and making instructions accordingly. I don't know, Christian and any of the others, if you are seeing that as well.
Sorry, Christian, you're muted, I think.
Sorry, yeah. Yes, we have, and we have also had the same thing in the past, because people always assume that in Germany things are way stricter than actually in GDPR, which is not true. But so it always had this approach of I want the advice in that country as well, but looking at the rest of Europe. But I think there's a tendency to really move it into this direction. Okay, Europe and then UK as well. Ted, sorry, you were raising your hand.
Oh, good. And you actually spoke partly to my question. I just want to be clear. So you're finding that companies are asking law firms for formal legal opinions as to compliance with GDPR, and law firms are willing to give that opinion?
It was a very specific request. So in the context of a contract that had already been signed between customer and supplier, the supplier had to obtain under the terms of the contract a formal opinion on whether a particular service line and the processing of personal data that took place in the context of that service line was GDPR compliant based on a desktop review of policies and information. So within the scope of all of that,
Okay.
yes, that was the opinion.
Got it. I was frightened that it might have been a more sort of far-reaching,
Yeah.
as opposed to
Yes.
helping with due diligence. Signing a formal legal opinion on general GDPR compliance would be an interesting task, I think.
A massive one. Yeah, no, I agree. I'm sorry, that sounded far broader than it was.
No.
It was a much more limited scope when we worked out what they actually wanted.
Great, thank you.
So thank you again. One of the differences that you didn't mention is that the new standard contractual clauses, now you have to use them if you are in Europe, and you at the moment have to use the old ones for the UK, which is sometimes very difficult to explain to clients, and I fully understand why. It's all a bit crazy. But it's a great opportunity to hand over to our colleagues from Finland to talk about these new model clauses.
Excellent, thank you very much. Yeah, my name is Asta Salo, and I'm from Finland, Helsinki, Finland, from Kastarenet Snellman, and I'm an associate working in our data protection and technology team. And so basically what I do, I work with data protection issues on a daily basis, and I'm joined here with my colleague Janina, who's a senior associate in the same team. And thank you so much for having both of us, because we both wanted to join and we couldn't really figure it out who got to come. So thank you so much for having both of us here.
Yes, thank you also on my behalf. It's the first time that I'm actually attending this meeting, and I'm maybe my practice is more maybe versatile compared to Asta's. I do also other things than the privacy, but really enjoy also exploring this topic. And if I'll start today, we will cover the topic of new standard contractual clauses that were actually recently given by the Commission, to be more exact on the 4th June. And I was thinking if you, Asta, would like to share. Thank you very much. Yeah, so basically there will be two sets of there are two sets of standard contractual clauses. Set 1 for use between controllers and processor, and set 2 for transfer of personal data to third countries. And basically, this was Commission's response to the judgment given by the Court of Justice of the European Union in Schrems 2 case, where basically the court decided that the privacy shield between EU and US was invalid, and but still maintained the validity of the old standard contractual clauses, but basically imposed more maybe or stricter requirements for the use of those clauses. Basically, data importers and also data controllers need to ensure that the protection in the destination countries equivalent to the protection afforded under the GDPR to the data subjects. And if not, then you are required to use supplementary safeguards. And if there are no suitable available, then you shouldn't go forward with the transfer of data to third countries. And of course, this relates to the bigger picture, whereby you need to have like adequacy decision, or then find appropriate safeguard for your international transfers. And basically, these standard contractual clauses, they aim to kind of create a tool that's easy to follow, but also kind of ensures that the legal requirements for international data transfers are followed. And somewhere Commission even expressed that this would be really suitable for medium and small and medium-sized businesses. And if we have a look at the improvements, then basically now we have one single entry point instead of several sets of clauses. And the Commission decided to combine approaches in a way that there are like certain general clauses, but otherwise the approach is modular. And the module 1 deals with transfers from controller to controller, and module 2 transfers from controller to processor. And then we have module 3 that's actually new. So basically transfers from processor to processor. And this was especially welcome addition, taking into account the fact that usually or very often processors actually have quite active role in international data transfers in a sense, and there was a need, for example, to get authorizations from the controllers to execute the deals and so on. So this will address that issue. And then also module 4, which deals with transfers from processor to controller. And this is also a new module. And module 2 and 3, they are also compliant with Article 28. So there is no need to have a data processing agreement in place if you do not modify the standard contractual clauses. And in a way, this brings more flexibility for especially complex processing chains, as there is this type of like this docking clause, whereby multiple parties can join and use the clauses simultaneously, and this basically would maybe make it easier if there are like several parties or companies as a part in the same contractual arrangement, and then they decide to use the same data processor, for example, for international transfer. So this could be one solution to address that problem. And maybe Asta could continue from here because you have more insights to the last point.
Yeah, sure. But what we're talking about, what kind of changes and improvements the new standard contractual clauses have, that they also address the issue of or try to bring more assistance to the data subject in case they've suffered some kind of if they in the need of any kind of redress or something similar. So the new standard contractual clauses actually shift more responsibilities also to the data importers, even if there are data processors. This means that, let's say that we have a big processing chain and we have many parties active in one same processing activity, then those parties are jointly liable towards the data subject. So this is also to kind of help the data subject navigate between where we should should focus our liability claim. So that's something that also these new standard contractual clauses try to bring forward. So not only the fact that it's easy for the parties to use, it's also easier for the data subjects to better protect their rights. But then if we look a bit at the timeline, I know that Christian, you mentioned that for instance in the UK the all standard contractual clauses are still in use, and in Europe at the moment you can still use both. If you have an agreement that relies on the old standard contractual clauses, you can still do so. But now from September onwards, whenever you have a new contract relying on any kind of standard contractual clause as a transfer mechanism, then it has to be the new ones. There is this transition period of 18 months from June this year until December of next year, where we can basically change all our existing agreements that rely on SCCs from the old ones to the new ones. And also that if we change our existing DPAs in a substantial way, that may also trigger a need to change from the old SCCs to the new SCCs. So this is definitely something that we need to inform our clients about, so that they are aware of this issue, that this is ongoing. And also during this transition period, there's an obligation to continue with these so-called Schrems 2 due diligence exercises, where we have to assess the privacy of the level of privacy in the importing country. And also, as Janina mentioned, these SCCs, if we rely on them as a transfer mechanism, we may not alter them. We can't alter them. We have to use them as such. Or then if we use any kind of supplementary measures, if the supplementary measures in some way contradict the SCCs, then we may no longer rely on the SCC as such as a transfer mechanism. So that means that triggers a need for us to then discuss with the relevant supervisor authority for an authorization for the transfer. So what this brings is it's easier for the parties to kind of bring them on and to use them, but because they may be used as such as DPAs also, it kind of takes away the negotiation power between the parties regarding the DPA. So this might be an issue that some especially some parties in a really dominant position have, that they kind of have to give that up if they want to rely on these SCCs as DPAs as well. So, but what do we do? What do we do now? What do we tell our clients? How do we advise them to go forward? Well, first of all, you have to know your transfers. This is all about data mapping, and here comes the Article 30 records of processing activities into play, and I don't want to rat anybody out, but the fact remains that that's a document that not that many companies have in place. They might have something that they've done in the beginning of the whole GDPR exercise, and then it's somewhere in a drawer and not really updated and maintained. So this is an excellent example of showing like why it's important to have your data mapping and your records of processing activities in place and updated. So first of all, we have to map all our transfers and then verify which transfer tools we use. Are we transferring based on adequacy decision or similar, or are we using any kind of transfer tool such as standard contractual clauses? Then we need to identify the level of protection in the destination country. And for instance, we have to assess that are there any kind of laws or practices that may may contradict with the SCCs. That are there any laws that may result in the SCCs not being enforceable in that country, and of course this might refers to the Cloud Act in the States and Section 702 FISA and so on. So if there are any of those kind of legislations, then we have to take these supplementary measures into play. With these supplementary measures, we can enforce even in technical or then contractual means that the data, matter of fact, is protected on an adequate level, even though it's transferred to a third country. And of course, the issue here is that if we look back on the whole Schrems II decision and what brought it on and all the changes that we're trying to bring with this new standard contractual clauses, that it doesn't really cover all the holes that we were hoping for it to do. Of course, it helps a lot, but for instance, if we look at transfers to the States, then it unfortunately does not work as such. And also that the EDP, the European Board of Data Protection, they actually stated that they cannot see any technical measures or supplementary measures at this time that would mitigate the risks to such a level that we could use, for instance, SCC for transferring data to the States. So, but what we usually want to advise our clients is to identify the data transfers and to map them, and then to document the diligence process. So to document the process that the due diligence process for assessing the level of privacy in the destination country. And this is of course something that you should agree with well, let's say the processor in this case, or the data importer, that they assist you with this due diligence exercise, and to document this and to assess whether you need any kind of supplementary measures, and then to document this, because this is of course something that the supervisory authority might want to see if they think it's necessary. And it's unfortunately, this is like everything with the GDPR, it's not enough that you do it once and then forget about it. This is something that you have to kind of maintain and do over and over again. You could do it on a yearly basis just to make sure that nothing's changed, or then if something changes in your processing activities, then of course take it for re-evaluation. But so this is even though it doesn't sound that it's like it's a lot of work, if we think that, okay, well, we just got a new template that we're going to use from now on, unfortunately that's not the case in practice. If we think about companies that transfer a lot of data, if they have a lot of partners in different countries, they might have hundreds of agreements relying on standard contractual clauses. The fact that you have to identify them, find them, and renegotiate all of those within the time span of, well, there's a bit over a year left. So that is definitely an exercise that requires a lot of work. And in Finland, I don't know how it's in the rest of Europe, but there hasn't been that much fuss about this. So this is definitely something that we need to actively bring forward and remind our clients about. Thanks.
Well, thank you both very much. Have you? I've got one question. The filling in annexes. I mean, these are templates, as you said. The old templates had two annexes which were which allowed companies to be very sloppy when filling them in. So I've seen standard contractual clauses with, I don't know, a few lines of annex describing the security measures and the data and the purpose and stuff like that. And the new model clauses require super detailed annexes, and so our clients do find that a massive challenge, and they then look to us and say, can you please complete it? But usually we can't, because it requires factual knowledge of the data transfer. Is that something you've seen as well? How do you deal with that?
Yeah, definitely, and that's not a new issue, as you mentioned. I mean, that's something that we already had with all standard contractual clauses, maybe even more so now. And I think that this is also a great opportunity to remind all of our clients about that. This is something that you have. It's not enough that you just refer to the standard contractual clauses or copy paste them into your agreement. You actually have to fill them in, and so in a way, this is an excellent opportunity for us to remind them that this is actually something that you have to do. And yes, we have the same issue that they look to us for assistance in filling them in. And that's of course something that we are more than happy to do as much as we are capable of doing with the knowledge that we have. And I think that our role is more of assisting them and guiding them in the right direction, and mentioning what points they have to fill in. But it's true that it's difficult for us to have the factual knowledge of the technical implementation that it requires.
I also think that our clients haven't been so active yet on this topic, so there probably will be hurry with this when the expiry of transition period approaches.
Yeah. Yes, I agree. There's a very strong tendency that I feel that people don't want to make use until they really have to. Do you know any cases where a data protection authority has actually requested to have a look at standard contractual clauses, old or new ones?
No, not really. We had our data protection authority mentioned earlier this fall that they're going to start reviewing or looking into these data transfers a bit more closely. So this is something that we've kept our eyes open and ears open and tried to see where this is going. But no, they haven't. Actually, they haven't been that active when it comes to especially the new standard contractual clauses. So this is definitely something that we're kind of waiting for it to happen, because it's difficult for any company whose main bread and butter is not ensuring that their data protection is up to date. Their bread and butter is doing something completely different. So it's difficult for them to take this massive time and energy to do something when they absolutely don't have to.
Yeah. Yeah, I agree. And talking about data protection authorities and their enforcement activity, I'll hand it over to Renee in a minute, but just let me explain and complain at the same time that very often data protection authorities have not proven to be very helpful when it comes to filling in or to giving any guidance on standard contractual clauses, at least not in Europe. By the way, that's one reason why I'm really sorry for seeing the ICO move away from GDPR as an actual member country, because they have been very helpful in providing useful guidance to companies, which also happened to be in English. So it was very useful for sending it to clients. And it's not the case for all of the authorities. And I have actually not seen a single case where I really got feedback from a data protection authority, from a supervisory authority on specific model clauses that they have looked at and really gave valuable input in terms of you should do this or you should do that. They have usually never touched it, but that may change in the future. So what we're trying to do, we have this, Renee will talk about it in a minute, is we have these enforcement tracker where we're trying to capture all data protection related fines under GDPR by supervisory authorities. And we really try very hard to be complete and to have them all in. So I challenge you, if you find any fine that's been public, that's been made public, and it's not in the database, I'm going to buy you a beer at the next opportunity. Just email it to us. And with that, I'm handing it over to Renee.
Thank you. So my name is René Sandor. I'm a senior associate in the data protection department at CMS Munich. I will give you a quick presentation on the GDPR enforcement trends that we saw over the last few years after the GDPR came into effect in May 2018. Let me try to present my slides. How does this work? I hope you can see this now. Can you see my slides? Yeah. If someone can shout, thanks.
We can.
Okay.
Yes.
Good.
They're good.
Good. So yeah, after the introduction in May 2018, things escalated rather quickly. We saw significant fines that even made it to media coverage on that. We can see media reports on the fine against BA in the amount of originally 180 million pounds. That was reduced later. I'll get to that. A fine against Google in France in the amount of 50 million euros. In Germany, a fine against fashion retailer H&M in the amount of 35 million. And then again in the UK against Marriott in the amount of around 100 million. That too reduced later, and yeah, I'll get to that too. And to have a look at the chronology of events, we can see that things started rather slowly in 2018. The data protection authorities followed an approach of investigation and looking into how companies implemented their GDPR compliance programs. But then in 2019, significant fines were levied, most significantly at the beginning of 2019 already, the fine against Google in the amount of 50 million euros. And then in 2020, that's the flat bit of the curve in the middle. Everything was obviously dominated by the outbreak of the pandemic, and DPAs also said that they would pause their enforcement actions, in particular for the transport and the hospitality sector, which were hardest hit by the pandemic. But then in 2021, the authorities reinvigorated their enforcement actions again, and significantly. You can see the spike at the right-hand side, which is actually attributable to the two highest fines that were ever levied, which is number one, a fine in Luxembourg against Amazon in the amount of 750 million euros, which is by far the highest. However, the details and the reasoning of the authority for that fine are still unknown. So unfortunately, I can't give you any further details on that. And number two, at the end of this year, 2021, was a fine against WhatsApp by the Irish authority in the amount of 225 million euros. There, the authority argued that WhatsApp had violated their information and transparency obligation towards users. So what's the baseline of this chart, of this slide? Overall, obviously, a significant increase. We're at 1.3 billion euros now today. And over the last 2 years, we can't say that there's a so to say COVID pause or break. And in general, GDPR fines are not a temporary phenomenon, but they are here to stay with us. So what are the reasons that authorities levy fines in the first place? Christian mentioned the enforcement tracker, and we've analyzed all published fines that we've got in the enforcement tracker. And number one of the types of violations that attract fines is that controllers can't rely on a sufficient legal basis for their processing operations, which makes the processing operation unlawful according to Article 5 and 6 of the GDPR. One example would be the H&M case in Germany, where H&M as a controller and employer put in place surveillance measures and illegally violated the employees' privacy. And then number two of the types of violation is insufficient data security or insufficient technical and organizational measures, which is a violation of Article 32 of the GDPR. An example here would be the BA case, where hackers were able to snatch customers' credit card data from the website. Moving on with another trend. So it's not only about an increase in fines, but it's also a trend that in a few cases, fines can actually be reduced. So in the cases of BA and Marriott in the UK, both fines were significantly reduced by the DPA. You can see the example on the bottom of the slide. The announcement in July 2019 said £183 million, ended up at £20 million in the end. Same and comparably, that happened to the Marriott case, where the fine was also reduced. In Germany, we saw litigation in the cases of 1&1, which is a telecom provider, and Deutsche Wohnen, a real estate company. And in those cases where the controllers appealed against authorities' fines, courts actually reduced or even at least temporarily dismissed the fines. So what's the reason for a reduction? One thing authorities said that would contribute to a reduction is a collaboration with the authority. Number two is data privacy concepts. So, for example, bolstered security measures. Number three is how did controllers behave towards affected data subjects? So apologies and a compensation that's offered to the data subjects is obviously appreciated. So those are reasons that can bring the fines down in the end. And what happened in courts in Germany? So in both cases, 1&1, Deutsche Wohnen, they appealed against the decision, and courts found, for example, in the 1&1 case, that the violation wasn't as severe as the authority thought it was, or at least they said that the amount of the fine wasn't justified for that severity of the violation. So we went from 9 million to about 900,000 euros in the end for 1&1. And I think this is also something that that will stay with us too. Another trend, which is litigation. So given that controllers can only reduce fines that were levied, we'll likely see an increase in litigation against data protection fines. So I'll end with the reading recommendation for you for tonight. The enforcement tracker, as Christian mentioned, is our comprehensive database, free to access for everyone. We're happy to receive your hints. You can make use of the filters that are available, so you can really tailor your search. You can look for fines in your jurisdiction, in other jurisdictions, and you can tailor your search. For example, if you want to look up fines which were levied for a lack of security measures, then you can use the filters for the type of violation. So I suppose that's really helpful. And we've also analyzed all the published fines in our enforcement tracker report, which I also recommend. And with that, happy to discuss, and thank you very much.
Thank you, Renee. And again, I repeat my offer for a beer if you find anything that we haven't found. It's actually more a community project than something that we do through our marketing department, which you can see from the design. So we've done this kind of as a stealth project. But it's been quite interesting to see where this leads and how hard it is to get all this information, because there is no common source that helps you to find this information. So we are already 1 minute over our 1 hour time, but still I want to give the opportunity for any questions that you may have. If not, you can always email us or email the group. And if you're not a member of the group already, you have to go to the website and subscribe to the group, and then you will automatically get emails that are being sent to the group. Hannah, this is still correct, I hope. I haven't signed up recently because I'm already in the group.
Yes.
Okay. So self-service, basically.
Mm-hmm.
But if you have any problems, just let us know and we will subscribe you. And if you have colleagues in your firms or from other World Law Group firms that you know of and that are not part of this group, also just let them know. This is not meant to be an elite club with only a few members, but I know there are more data protection lawyers out there than we have currently in our list. So again, forward this to your
Christian,
colleagues.
I'd just like to echo that there's not a requirement for years of practice. So if you have younger lawyers who you want to get involved in the fold or come for a learning perspective, whatever that is, they're also welcome to attend. And the self-service pretty easy. You go to our website. If you already have a profile, you just log in, you can edit your profile. And if you don't, you can just create one using your law firm's provided email address.
Perfect. So thank you all for your presentations, and thank you for taking part in this call. I hope it proved to be useful to you, and I hope to see you or hear you or both in our next call. I think we don't have a date yet, but we will send one in the near future.